The Private Placement Memorandum, Due Diligence, and the Term Sheet by Craig Diebert for MBA 230, assignment number 3. In the early phases of an entrepreneur's start in a business, one of the main hurdles to growth is lack of capital or cash. Cash will allow an entrepreneur's business to grow. Cash can be spent on research and development, investment in facilities, hiring of personnel, advertising, and so on. With no cash but a great idea or possibly great sales on a very small scale, an entrepreneur has nowhere to go next. At this point, the entrepreneur will take steps to acquire funding. In the same manner, an already established firm may come to the same point as the entrepreneur, where there is a need and ability to grow without the ability due to a lack of capital or cash. An established firm may be at the end of a period of R&D with an exquisite product to produce, but have a lack of cash to invest in facilities to produce the product. Without the cash to invest in the facilities, there is no ability for the firm to move forward with the new product line. A firm has two methods to gain capital or financing. The two options of financing are debt financing and equity financing. In debt financing, the firm will go to a financial institution and establish a method to borrow money and invest in the firm while paying back the institution the principal and interest over a time period set by the terms of the loan or note. The point of this discussion is to outline the method of selling a private firm's equity for the purpose of raising capital. In this discussion, we will outline the legal background of the private sale of equity. The private placement offering and private placement memorandum process will be discussed, which is similar to a prospectus in the public equity market. The due diligence, which is the research done of a prospective target firm prior to and during negotiations, and finally the term sheet and the subscription agreement will be discussed. This will give an understanding of the private equity market and the process of sale of private equity. The law surrounding the securities market originates in the Securities Act of 1933 and the Securities Exchange Act of 1934. These laws were created during the Great Depression. There were three main points of these laws. Number one, investors should be provided with all essential information prior to investing in speculative ventures. Number two, corporate insiders should not be allowed to abuse their position and use non-public information concerning their companies to their own financial advantage. And three, misled investors should receive adequate relief even in the absence of common law fraud. These laws do well in regulating the public equity market, but are tedious and costly to follow. For this reason, the government created exemptions to the laws. Based on the rules established in the 1933 and 1934 securities laws, it is illegal to sell securities unless you are licensed to sell them or you are exempt. Along with Regulation D, other exemptions exist as well. Section 4.2 exemption, Section 4.6 exemption, and Regulation A. In the market of private equity sales, Regulation D is the most standard to use and will be touched on for an understanding. Regulation D is comprised of 6 basic rules. They range from 501 to Rule 506. Rules 501 through 503 are associated with definitions, limitations, information requirements, and SEC notification requirements. Rules 504, 505, and 506 are specific to the actual exemptions of the SEC equity sale requirements. Each rule has specific rules to be abided by a seller of equity, which deal with the amount of money that can be raised in a time period, the types and amounts of investors that can invest in the security, and types of disclosures that must be made to the investor. A brief explanation of each follows. Rule 504. This rule is the most common to be used by a small firm looking to find equity financing. The rule will allow a firm to raise up to $1 million. There are no disclosure requirements. There are little solicitation and resale restrictions, and there are no limit to the number of and type of investors. When Congress revised this rule in 1982, the intent was to set aside a clear and workable exemption for small issues to be regulated by state blue sky requirements, but by the same token to be subjected to federal anti-fraud provisions and civil liability provisions. Rule 505. This rule will allow a firm to raise up to $5 million in a 12-month period. There are required disclosures that must be made to the investors who are not accredited. The securities cannot be sold for a certain time period after initial sale. The firm must make financial documents available as well as to have them audited. The non-accredited investors must receive disclosure information similar to that in a public offer disclosure. The term accredited investor is a term that means the investor meets certain requirements which accredit the investor with a certain amount of business acumen and savvy. And lastly, Rule 506. This rule will allow a firm to issue an unlimited amount of securities. The number of investors is limited by both number and accreditations. The non-accredited investors must be sophisticated. As with Rule 505, advertising and general solicitation are prohibited. The securities are restricted and cannot be resold. This rule will supersede and preempt the security laws of all states. In the sale of securities, a firm must also meet these exemptions along with the other rules governing the sale which lie in the individual states. These are called blue sky laws. Blue sky laws were the precursors to federal securities regulations and were aimed at promoters who would sell building lots in the blue sky and fee simple. Blue sky laws may need to be abided by in any number of states concerned with the sale of the equity. This has been a brief explanation of the law behind the sale of private equity, and will give a better understanding of the process of the sale of private equity from this point forward. The private placement offering. The private placement of securities occurs when a company makes an offering of securities to an individual or a small group of investors. Since such an offering does not qualify as a public sale of securities, it does not need to be registered with the Securities and Exchange Commission, the SEC, and is exempt from the usual reporting requirements. Private placements are generally considered a cost-effective way for small businesses to raise capital without going public through an initial public offering. A private placement of securities must abide by the rules set by the SEC to be exempt of the heavy regulations in the securities laws of 1933 and 1934, as discussed thus far. Abiding by the rules of the exemptions and the disclosures necessary are best done through the use of a private placement memorandum. A private placement memorandum, PPM, is basically a prospectus for shares in a private company, much like the sort received by an investor in a stock, mutual fund, or other publicly traded security. It details all of the terms of the investment, requirements of the investor, and proper disclaimers and disclosures related to the business and equity. The start of the discussion of the contents of a private placement memorandum is best explained by the following. The private placement memorandum contains a number of sections aimed at informing the investor. A term sheet or summary details the specific terms of the investment. Legal disclaimers explain the specifics of how the private placement works. A section on the risks details the specific and generic risks associated with the business. Charts show how the business is capitalized and the dilution of stock that the capital raising will cause. A subscription agreement is the contract that must be signed to move forward with the investment. The main point and purpose behind the private placement memorandum is to add a level of protection to the firm selling the equity through the disclosure of information to the buyers of the security. This will lessen the rights that the buyer of the security will have to come back in the case of the investment not succeeding. As mentioned earlier, the first area addressed in the Private Placement Memorandum, or PPM, is the term sheet. The term sheet will be addressed later in this report. The second area addressed in the PPM is the legal disclaimers affecting the private placement. This area will most likely cover the area of the exemptions taken under the SEC rulings. This will address how these exemptions are addressed and how they will be followed. The third area to be addressed, and possibly one of the most important, are the risks. It is important for firms addressing the possible risks of the firm to understand that the point of the PPM is not to be a sales pitch to potential investors. The risks need to be well spelled out and involve not just those specific to the business, but also those generic to the industry. One piece of advice when addressing the risks of the business is to begin with the income statement of the business. Addressing the risks associated with each line of the income statement. Address the risks associated with a decrease in sales and then address an increase in sales. Go all the way down the income statement and then move on to the balance sheet. Again, it is extremely important to list and disclose any risks by the firm in the PPM. If the risks that were known by the firm later come to fruition, the firm selling the equity may be held liable in a case of litigation. In the worst case scenario, the firm may owe the investment back to the investor. It is important to realize in the case of entrepreneurs seeking investors, the entrepreneurs may be extremely optimistic of the future of the business, but the PPM is not the place to show that optimism. The fourth area of the PPM will be the explanation of the capitalization of the business both before and after the dilution due to the sales of the equity. It is important for the investor of the security to understand the current financing of the business to understand how the financier's equity will come into play. Along with the capitalization, the PPM will also have prior and current financial information about the firm as well as future projections. The last section of the PPM will be the subscription agreement, which will be signed by the purchaser of the equity. It is important to remember, though, that the PPM is not a business plan but can be considered as similar in many areas. Whereas both show actual and projected financial statements in some detail on the management and operations of the business. However, the business plan goes into much greater depth on the market research, strategy, and tactics of the business. The business plan cannot hold an offer for investment within its pages. This is reserved for the PPM only. The PPM is focused on risks and disclosures. Often the business plan in its entirety is included as an exhibit of the PPM. Private placement memorandums are often written by lawyers, and the cost of them can range from $3,000 to $20,000 and up. Companies exist on the internet in the business of creating PPMs. The companies that exist on the internet to help in the creation of PPMs vary from selling templates, which a business can fill in with appropriate information. If a firm is using a template to create a PPM, it is still advised to take it to an attorney for review. There are also companies on the internet that will take the information of the business, research the business, and create a PPM for a lower price than walking into a lawyer's office. The research seems to show that the value of the PPM is not in the lack of cost, but in the added level of protection for a firm selling the equity through the full disclosure of the information held by that firm. In an additional note regarding the company or attorney chosen to create the PPM, many internet providers of PPMs will also mention that they have a large network of investors that may be able to be tapped with the use of those firms in creating of the PPM. A firm may want to take advantage of the connections a business creating their PPM may have. A basic understanding of due diligence can be explained as follows. Due diligence sounds impressive, but ultimately it translates into basic common sense success factors such as thinking things through and doing your homework. The due diligence period is following the period of the private placement offering. After an investor or investment group has found interest in a security, possibly through a private placement offering, that investor or investment group will begin to research the equity to be purchased. This research is the due diligence. The main party involved in due diligence will be the investor or investment group. The investor or investment group may also include lawyers of the investor, bankers, accountants, loan officers, and etc. The target company needs to be available to assist in the investigations. The due diligence will typically be performed until the acquirer can learn such that the acquirer can lower his risk to the appropriate level and make good informed business decisions. It is important not to overdo the due diligence to the point of having analysis paralysis, upsetting the target firm, or missing out on the investment. Other factors that are involved through the due diligence period are costs that are typically decided on by the parties involved. Confidentiality must be handled carefully due to the time period of the sale of equity of a firm sometimes being a risky time period. When confidentiality is broken, firms may suffer with the public knowledge of the firm's equity being sold. In addition, unscrupulous competitors who find out about this information may make false allegations of the event to the SEC to hold up the process of the sale. The question of what is researched in the due diligence will most likely come down to the management team, the technical capabilities, the sales and marketing strategy, and the financial wherewithal of the business. Through all the research during the time period of due diligence, it is important to understand that this will not guarantee a successful business dealing, but will only decrease the odds of failure. After the private placement offering and time period and work done on the due diligence of an investment, and if the acquirer is interested in acquiring equity in the target firm, negotiations will begin to take place. Most likely, the negotiations will begin verbally without written documents. At that time, the offer is written for the purchase of a firm's equity. It will most likely come from the acquirer, and it will be in the form of a term sheet. A term sheet is a pre-acquisition, pre-funding agreement that shapes the understandings of both parties. The purpose of the term sheet is to outline the proposed transaction terms as well as indicate the value of the transaction. A term sheet is a document prepared by venture capitalists that sets forth the key terms of a proposed investment. The temptation for the entrepreneur is to focus mostly on the overall valuations of the transaction, but this can be fatal. Keep in mind that a term sheet has a variety of protective clauses for the venture capitalist that can have significantly reduce the valuation for the entrepreneur. As a result, it's imperative to have an experienced attorney negotiate a term sheet with you. The term sheet will have many areas of specifics to the negotiation that will not only consist of what the value of the company will be before and after the investment and the percentage to be owned by the investor, but will also contain some of the following areas that will need to be navigated by the target company. The term sheet will most likely be seeking preferred stock for the investor. As well as receiving dividends, the preferred stock will also secure voting rights for the investor and liquidation preferences. In the case of the business failing, the order of payment and liquidation starts with the debt holders being paid first, then the preferred stockholders, then the common stockholders. The founders of the business are usually holding common stock, and in the case of liquidation, will be the last to receive any remaining funds. Dividends will most likely be requested in the term sheet and are tied to the preferred stock. The investors in the business will want guaranteed cash flow in the form of dividends throughout the life of the investment. Reverse vesting can be used in the term sheet to take away the ownership of the common stock from the managers of a business and give it back through a vesting schedule. This is a method for the investors to make sure that the managers of the business stay with the business for a certain period of time to see that their investment is managed soundly. Legal fees will need to be foreseen in the term sheet negotiations of the financing. Not only will there be legal fees associated with the use of attorneys to support the negotiations of the term sheet, many times through the due diligence, contracts, and internal corporate cleanup will need to be done. A no-shop clause in the term sheet will not allow a firm to shop for another venture capitalist during the time of negotiation of the term sheet. This will most likely not be negotiated away, but many times a firm can limit the time period which will add a completion date to the negotiations. This overview of the term sheet gives a basic understanding of its nature, but a more in-depth look will need to be taken and most likely professional help sought prior to negotiating one. The final step in the process of private equity financing is the subscription agreement. The subscription agreement gives the necessary information for a subscriber to move forward with investing in a private placement. This includes the price per share being acquired and the number of shares. The legal language explains necessary confidentiality provisions, which state will govern the agreement, and the rights and requirements of the subscriber. The agreement also should require the subscriber to certify that he, she, or it is accredited and has not been solicited so that the seller has a record that the proper procedures were followed. The advice about the subscription agreement is to keep it simple. There is no need to readdress the information held in the private placement memorandum. The subscription agreement should outline the agreements made in the negotiations and again should most likely be looked over by an attorney as well. These steps outlined above are to be taken to acquire equity financing for a business seeking capital for the purpose of growth. Though equity financing may be the next step necessary to grow a firm, there are important steps to take to gain this financing and stay within regulations and without taking on a great deal of risk. The key points in equity financing deal with accurate disclosures and legal assistance. These methods should be followed consistently through the process to successfully navigate this financing. This concludes this presentation. Thank you and goodbye.